Tonight, we're diving into a case before the U.S. Supreme Court that could have major implications for workplace discrimination lawsuits. The case, Ames versus Ohio Department of Youth Services, involves a straight woman, quote unquote, who claims she was passed over for a promotion and later demoted because of her sexual orientation. The justices seem to be leaning in her favor, questioning whether the legal standard for proving discrimination should be different for majority and minority groups. This case is unfolding as major corporations and government agencies face growing legal challenges to diversity, equity, and inclusion initiatives, many sparked by last year's Supreme Court ruling on affirmative action. So what does this mean for workplace protections? And could this ruling shift how discrimination is handled in the courts? To break it all down, we're joined by Elie Mystal, justice correspondent for The Nation. Elie, I'm a great fan of your work, and I really want to thank you for being here. So for those who may not fully be aware, can we start with the bigger picture? How significant is this case, and what impact could it have on future discrimination lawsuits?
Okay, so I'm going to kind of answer the question two ways. It's very significant, but I actually don't think it will have a huge impact on the future of anti-discrimination lawsuits, at least if the case kind of stays the way that it seems to be going from the Supreme Court. So that's a little bit complicated. So let me start with the actual lawsuit, all right? Marlene Ames is a straight white woman who claims that she was passed over for promotion when they hired a gay person for the job. And that's it. That's her entire evidence. No pattern or practice or history of racial or sexual discrimination, no larger background issues. It was just she wanted the job and they gave it to a gay person. So clearly she was looked over because of her heterosexuality. If white fragility could be a Supreme Court case, this is what that case would look like, right? Now, everybody out here knows you can't bring no discrimination lawsuit if all you got is that they promoted a white man ahead of you, right? No black person can do that. If we could, we'd have a lawsuit every Tuesday, right? So we understand that you need to bring more evidence than just they hired some other person that doesn't look like you for the job, or else, again, discrimination lawsuits would be all over the place, right? So now Ohio is a very special state in terms of it's how federal law applies there. It's one of the only states, there are like a couple of them, that have this very archaic rule, judicial rule for civil rights complaints. Now, obviously, anybody, white, black, brown, green, whatever, can sue for racial or sexual discrimination. But in Ohio and a couple of other states, if you are a member of the majority, which usually means white, in this case means straight, you have to show a background pattern or practice, right? You have a heightened standard of proof to bring a racial discrimination case, right? This makes sense if you think about it, right? If I'm black and I'm suing for racial discrimination, I shouldn't have to prove that racism exists, right? Like we can skip the remedial white history part of the class and just go straight to my individual complaint, right? But if you're white, since, this country does not historically discriminate against you, since this country does not historically discriminate against straight people, then you kind of have to prove that there is something else in the history of your organization or institution that points towards discriminatory behavior before you can bring a civil rights case, right? Now that, again, Ohio is one of the very few states that has it. The Sixth Circuit Court of Appeals, which controls federal law, and Ohio is one of the few circuits that still allows for this kind of heightened standard. And so at the Supreme Court, the main thrust of the argument was, well, let's just get rid of that rule. We already don't have that rule in New York. We already don't have that rule in Florida. Let's get rid of that rule, and then everybody can sue for racial discrimination without having to meet a higher burden, which is, the white people can sue under the same burden as black people. And as I already said, this woman most likely cannot prove a racial discrimination case or a sexual orientation discrimination case based on the evidence that she has, because all she's got is they hired a gay person. So what? That's not normally enough under any standard, much less this heightened standard, right? So in terms of significance, that's what I'm saying, maybe not so much, because just letting white people sue under the same rubric that white people can in Ohio, that white people can sue in Florida, doesn't change the landscape too much. What could change the landscape is that there was this other kind of argument just underneath the top level Supreme Court back and forth. And that's this argument that was put forward by Stephen Miller and his America First legal team, that says that anything, any opportunity, any way that any corporation or institution that has a DEI program is de facto discriminatory, facially discriminatory against white folks, right? So think about how that would change the standard, man. It would change the standard so that now white folks, instead of having to have a heightened standard to prove discrimination, they have no standard at all. They don't have to prove discrimination one bit. They can just say, hey, they have a DEI program and they hired a gay person, so now guess what? I was discriminated against, right? Like, that is the argument Stephen Miller wanted the court to adopt. Now, as I listened to the case, I didn't hear 5 votes for that. Neil Gorsuch was kind of interested, but for the most part, I don't think that they got 5 votes for that more radical argument. So my thought is that this case will actually come down 9-0 with even the liberal justices, even, Ketanji Brown Jackson and Sotomayor and Elena Kagan joining the conservatives to get rid of this one rule, but protecting, but rejecting the larger argument that Stephen Miller was trying to make that was hyper-focused on DEI as facially discriminatory against whites. So I think it's going to be a bad ruling, but when you see a bad ruling that's 9-0, it's always important to think, well, what were the liberals actually trying to avoid? Because usually what they were trying to avoid is something much, much worse. And I think that's what's going to happen here. At least I still have hope that is what's going to happen here.
So this is kind of triggering, Michigan, the University of Michigan, affirmative action, lawsuits back in the day. My concern is that with something like this, even with, this 9-0 decision, we live in this country right now where everybody's talking about Trump and Republican mandates, that so many people across the country will feel like emboldened to go against anything they see as discriminatory, even if, like with this case, there's no real basis, and they'll cite a 9-0 Supreme Court decision, even though what they actually might be deciding on is not exactly what they would be trying to sue on. Is that accurate?
Oh, you're exactly right. The lawsuits are coming, and like I said, if white fragility was a Supreme Court case, this is exactly how it looks like. The lawsuits are coming, and anybody white who ever has to suffer the ignominy of seeing a black person get a job that they think that they are entitled to, that white person is going to feel emboldened to sue. And it's going to come at any black person who gets a job, any LGBTQ person who gets a job. Like, those lawsuits are coming, and there might be Supreme Court cases down the road that do adopt Stephen Miller's argument and do de facto facially rule that any DEI program is a violation of the Civil Rights Act. So those lawsuits are absolutely coming. They wrote it down in Project 2025. Like, they literally said that they want to flood the zone with these kinds of lawsuits. It's going to be incredibly bad going forward in terms of trying to just defend the fact that you have a job while black, because white folks in this country are going to argue that there is no job that a white person couldn't do better. That's the crux of their argument. So absolutely, these lawsuits are coming, and it's going to happen increasingly as long as we continue to allow Trump and Musk and Republicans to control the White House and Congress and the Supreme Court. That's the sad reality that we're all living in.
And as we're talking about this reality, what are you seeing from your broad experience right now as it relates to basically how they're ending DEI in other spaces, but at the same time, basically asking for DEI for themselves? How are you seeing this play out on the colleges, in corporate spaces, and nonprofit organizations? What is the bigger picture that people should be paying attention to as this is happening?
Well, remember, no lawyer that I am talking to right now is truly fighting for DEI. DEI is a policy invented by white people to comply with the 14th Amendment and the Civil Rights Acts and their guarantees of equal protection under the law and equal employment opportunity for all, right? Black people are not asking for DEI. Black people are asking to be treated fairly when we apply for jobs. And it's white folks who are just like, oh, I can't do that. If you leave it up to me, I'm always going to hire Chip, right? Like, white people who could not figure out how to hire people on, wait for it, merit, instead of hiring the most meritorious person for jobs would consistently hire the whitest person for jobs. White people invented DEI to force themselves to hire black people who deserve to have a job, who deserve to have an opportunity, right? So now as white organizations and white companies and white government is trying to take DEI away, I'm not fighting for DEI. What I'm fighting for is the Civil Rights Act. My mother did not march for DEI. She marched for the Civil Rights Act. And so my question is always, well, if you're going to take away DEI, how are you going to still comply with the Civil Rights Act? How are you going to promise and prove that you are hiring people based on merit as opposed to based on whiteness? Because every time you take away DEI, what's happens is that you only hire people based on their whiteness. So how are you going to solve that? And that is the larger issue here. These organizations and companies that are trying to take away DEI, they're not saying we're going to hire the most meritorious person for these jobs. They're saying we're going to hire white people for these jobs. They're saying that we never really wanted to hire black people in the first place, and so now we can just fire them. Look at what's happening in the federal government. People who happen to be black, who did not get their jobs through a DEI program or anything like that, who have literal years of experience and expertise in their government jobs, are being fired simply because they were black while having the job. The person that I keep trying to remind people of right now is this woman named Gwen Wilcox, who was a commissioner for the National Labor Relations Board, is exceptionally credentialed, has a long professional work history, and she was fired for the crime of being black while in government. There's no anti-DEI argument to support firing Gwen Wilcox. If you want to fire people, you have to look at their record. You have to show some kind of cause. Gwen Wilcox was just a great commissioner for the NLRB. She was fired because she was black. And that is happening throughout government. That is happening throughout corporate America right now. And that is what I'm fighting against. That's what most lawyers are fighting against, not the government's ability to end a white program that they invented and they called it diversity, inclusion, and investment initiatives. We're talking about following the 1964 Civil Rights Act.